Hello, and thank you for participating in the Lobby Days with Justice Forward Virginia. My name is Shawn Weneta. I am now formally with the Humanization Project, but of course still working with them. I now am a policy analyst for the ACLU of Virginia. But I'm here to talk to you today briefly about second look legislation, which is moving forward in the 2022 General Assembly, and we are particularly excited about it. What second look legislation allows somebody to do is somebody who's been incarcerated for an extended period of time, it allows them to petition their sentencing court for a review of their sentence to determine if it is still appropriate. It is done after a certain period of time, typically after a decade or more in prison, and it makes the court take into account all of the rehabilitative efforts that the person has made while they're incarcerated, including treatment programs, therapeutic programs, education, perhaps the person earned a trade, earned their GED, perhaps established relationships in the community, reconciled with family. Maybe they have a job waiting when they get out. Perhaps they've engaged in, participated in completed substance abuse treatment, anger management, all these different sorts of things that they might have done to grow and mature and ensure that they'd be successful if they were to be released. So the person would petition their sentencing court and ask the court to review their sentence, and the court could then choose to reduce their sentence, suspend their sentence. They could suspend all of it, let the person out immediately. They could suspend a portion of it, make them do a little bit more time, maybe add some more programs or things like that the court would like to see out of the person over the next couple of years, and maybe give them a bit of a roadmap towards what they'd like to see before they reduce the sentence. Now, while it is important to certainly look at this in a retrospective manner, I believe it is more important to look at this in a prospective manner and how this is going to impact cases moving forward. And what this allows prosecutors particularly to do moving forward is to approach a victim of a crime and let them know, hey, this defendant is going to prison probably for a long time. But what would we, you as the victim and us as the Commonwealth, like to see out of this person while they're incarcerated? Would we like to see them earn a trade? Would we like to see them get their GED, perhaps participate in anger management or substance use disorder treatment, or all these different types of things that are available to somebody while they're incarcerated? Would we like to see them perhaps line up a job? Would we like to see them get a trade? The court spends a lot of time, and the Commonwealth spent a lot of time determining guilt and determining terms of probation and post-release, but they really don't fill that gap there. We sort of hand that off to the Director of the Department of Corrections. And Second Look allows victims to have a say and empower them to have a say in how the person serves their time. It allows the Commonwealth to have a say in how a person serves their time. We believe that empowers victims. It empowers the Commonwealth. The other thing about Second Look is, when the person comes back to court to review their sentence, is it provides for transparency. The person's institutional record is given to the Commonwealth. It's given to the courts. It is reviewed. The victim is brought back into the equation as well. They are notified. They have to be notified per this bill. It allows for transparency. It informs the Commonwealth. It also allows the community to be involved because they're going to be in the courtroom. They're going to see what the decision is. They're going to see why the decision is made because the court has to issue an opinion on that. The reasons why they either denied a petition or the reasons why they granted a petition. We know that that's been sort of some of the things that have been of concern lately with the parole board for the very limited amount of people that are still eligible for parole, as well as even with the pardon process. We want to bring transparency to the process of reviewing somebody's sentence, and we believe the most appropriate place to do that is in the courtroom, with the prosecutor, with the victim, in the community where the offense occurred, and it best understands the impact of the crime. And it should be in front of that local community as well, which happens here in the courtroom, so everybody gets to see it. That is sort of a general overview of it. We certainly look forward to discussing it with you more. Of course, I'll be involved. You'll be seeing me a lot on this piece of legislation. We will look forward to discussing the nuts and bolts and the intricacies of the policy itself. If you're a bit of a policy wonk like I am, we look forward to telling you more about that. Please engage us with questions, concerns. We'd like to know maybe if there's a blind spot that we haven't considered. We look forward to discussing that with you further as we move into our lobby days and move forward into the General Assembly session here in a couple days.